Dr. Barrister, let's look at criminal litigation and bail in Cameroon. There's granting of bail in criminal litigation in Cameroon. Why did you choose this topic?
Well, I chose it because granting of bail in criminal litigation is very fundamental in securing the release and liberty of suspect, defendants, or accused persons. You know, to lose your right of liberty is so difficult, it's so bad, and most of the times that is what is being used by our officers to put suspects or accused persons under duress for them to say things which they ought not to say. I wish to make it clear that the right to liberty is so sacrosanct and is protected by international laws like the ICCPR and many other international treaties, human rights treaties. And so it was a well thought of field of research in order to promote right to liberty during criminal litigations in Cameroon.
So how can this now be of help now to the common man? Because you have talked about the fact that liberty is something very extreme, and when it's taken away, it's very bad for an individual. And sometimes people get to confess things that they have not done, just the fact that they need to have this liberty.
Yes.
How is this topic now going to be of importance to the common man on the street?
Well, it is important because the common man will know from what I did that there is a right to bail. That whenever they're confronted, they're called on, or they're summoned to appear, or invited to appear in front of a judicial authority, either as a suspect, that is when you are safe in front to meet under investigation before the judicial police officers, that's gendarmes and police, or when you are to meet when you're under preliminary inquiry, that's in front of the examining magistrate, or when you are in court being tried, you should know that the law provides that within this period of time you can ask temporary liberty and be granted in the fulfillment of certain conditions. So many people don't know that during the criminal litigation there's a provision that actually gives you liberty if you apply for and meet up those conditions. So I think it's very, very important to the normal, to the common man. And as I said, right to liberty is so sacrosanct in every society. You know, some people think that right to life is the highest right. But what is right to life when you are not free? You see, people will not want to live if they have to live. People will not want to have life if they'll spend the whole of this life in a prison or under torture. You see, so it is very sensitive and very profitable to the common man to know that each time they receive a summon, they should not be afraid, because the law provides that during the criminal litigation, because you have to start from investigation, you go to court, the judgment, appeal, or they should know that the law has made provision. The Criminal Procedure Code of 2005 has made provision for them to be granted bail upon the fulfillment of certain conditions.
No, but Barrister, let's look at this in critical context. Someone is summoned, the person willfully go to attend the summon and is locked up and request a bail, and they tell you you don't have the right to bail. These are practical cases. Now, how do we go from there if we experience such cases?
Okay, we'll start first of all to examine those offenses that the law provides that you should be granted bail. The law makes it very clear that in simple offenses, that is a loss of liberty within, I think, within some few days, and a fine of 20,000 or 25,000, you are automatically bail is automatically granted to persons under that who've committed such an offense. So when you move from simple offenses to misdemeanor, the law says that misdemeanors are bailable offenses, but misdemeanor committed flagrant delito, that is when you're caught in the commission of that act, or sometime after the commission of that act, and in possession of what, for example, if it's theft, you're caught with the property stolen sometime just after the act, the law says that you will not be granted bail in such a situation. And I think that the spirit of the law then is that all the proofs are there for you to have a fast trial. But yet, that does not reflect the reality of our society, because No trial is very fast regarding our court systems. You see, every magistrate has, you go on the roll, you see that a magistrate has about 200 cases, 150 cases, and you cannot determine those, you cannot hear those matters